Okay, so our next required reading for this week is Crescendo Management and Westpac, that case, which is an economic duress case, and it also looks at inducement. Okay, so in terms of the facts of this case, Hillbrink was a director of the Upward Group of companies, which comprised two companies that were in a state of indebtedness to Westpac. The directors of the Upward Group decided to relocate the company premises from Mortdale in Sydney to Picton. And as a result, Hillbrink and his wife decided to sell their house at Oyster Bay and to move to Picton. And they sold their house in July of 1977. And the net proceeds of $31,000 from the sale was received by Westpac head office as mortgagees. Hillbrink claimed Westpac was authorised to deduct an amount to discharge a long-term loan secured by the Oyster Bay property and overdrafts on his personal accounts. And one half of the balance of the proceeds of sale was to be credited to Hillbrink's account with Westpac, while the other half was to be transferred to an account held in his wife's name at the Picton branch of the commercial banking company. However, Westpac transferred the entire balance of $27,700 to its Mortdale branch, which was of the Upward Publishing Co. and Upward Productions. So the bank refused to release the monies until mortgages had been executed by Hillbrink's company, Crescendo Management, to secure the debts outstanding in the name of the Upward Group. Because the monies were required to complete the Picton purchase, the Hillbrinks signed the documents. However, and despite their apparent lack of protest, they then claimed that the documents were executed under duress. So the key issue before the Court of Appeal was whether the withholding of the balance of proceeds of sale until documents had been executed to secure the indebtedness of the Upward Group, whether that amounted to economic duress. The Court of Appeal unanimously held that although economic duress could actually be made out on these facts against Westpac, the pressure caused by the bank's conduct actually played no part in Crescendo Management's decision to execute the documents. Okay, and we'll come back to the reasoning in the decision a little more closely with the case reading guide questions, and it's to do with the timing of the pressure. Okay, so in terms of the questions we've got here, in the case, Crescendo, a company controlled by the Hillbrinks, gave a mortgage of property as security for the indebtedness of Upward Production, another company controlled by the Hillbrinks. So what was the pressure alleged to have been applied by Westpac to obtain the mortgage from Crescendo? And that was that it would not release the $27,000 to Mr. and Mrs. Hillbrink until certain documents were executed. In terms of the second question, is relief granted whenever the party claiming relief acted under pressure? Okay, the answer is no. Okay, so it's not every time. And what did Justice McHugh say was the basis for granting relief when pressure is applied to secure a contract? Justice McHugh stated that the proper approach is to ask whether pressure induced the victim to enter into the contract and whether that pressure went beyond what the law is prepared to countenance as legitimate. So it's those two elements of duress that we talked about in the overview PowerPoint. Pressure will be illegitimate if it consists of unlawful threats or amounts to unconscionable conduct. So you need to keep in mind then, according to Justice McHugh, that even overwhelming pressure, not necessarily amounting to unconscionable unlawful conduct, will necessarily constitute economic duress. So those two elements of economic duress need to be met. And here there was a problem with whether, so that pressure did exist, it was recognised, but the question was whether the pressure actually induced them to enter into the contract. Was it a reason, which we know from Butler and Armstrong, the test, was it a reason for entering? And here it was found to not be, but we'll come to that in a sec. All right, so in terms of the third question, did the bank have the right to withhold payment of the proceeds of the Oyster Bay sale from the Hillbrinks? No, they didn't. So this was illegitimate pressure here. That element was clearly made out. But when we come to the fourth question, you're going to see the problem for why the Hilberings weren't successful in this case. Does the pressure applied have to be the reason the party seeking relief made the contract? Doesn't have to be the only reason, which we know from Barton and Armstrong, but it does have to be a reason. And why did the court hold that the mortgage had not been given as the result of the pressure? It was entered into, the agreement was simply entered into before the pressure or threat was made. So it was just around the timing of it. Okay. So because the timing happens later, it wasn't a reason that they entered into the document, contract. Okay. All right. So that is Crescendo Management, a nice quick one.